The way we choose our clerks, we have a pool and we each decide which clerks we are going to be interviewing. We don't all interview the same clerks. And our present clerks do assist us in, going through that material. I would tell them to look for someone who has demonstrated research ability, demonstrated writing ability. What I mean by that is I'm not assuming that someone, just because they've graduated from law school, that they can research and write. So I like someone, for example, a demonstrated research ability. They were head of the law review and so on. So I asked their assistance on certain criteria. And then we all interview a certain number of clerks. And I think our process does work. We do choose by seniority, but not entirely so. The chief chooses her three. And then for the first clerk, we go by order of seniority. The second, reverse order of seniority. The third, we go down again. I think it's pretty fair that way. I think you have to think very widely, as wide as possible, but right narrowly. I've always said that to my clerks, research and think wide, but this judgment is going to be narrow, so let's think together how we can do this. Law clerks are very important on this court. I came with the view, many people from outside say, my God, 3 clerks, what do you do with them? We need them. And they are very important because there's so much work and so many facets. It didn't take more than a year for me to appreciate that you do work closely with these people. And it's not just a question of looking for the raw ability that you would see in a CV or whatnot. You want to be able to have a rapport, an easy rapport. They play a huge role in helping us with preparing for cases. There's a huge volume of material to go through. And the clerks go through that material. They prepare bench memos is what we call them. And the way I use that is I tell them this does not replace my reading of the primary material, the facta and the decisions under appeal, but I'm not going to read all the transcripts unless it's really a focused question that requires that exercise. But they really are helpful in that way. I'd ask my clerks, tell me when the penny dropped for you, because you have this load of material to read. And you'll start somewhere. It could be the decision below, the factum of the appellant, but the penny might drop when, lo and behold, it's one of the respondents, a factum, and you say, oh, that clarifies. Give me that penny, the penny drop moment. And many would write their bench memo and say, penny drop, all right? The clearest view of the facts that is really helpful here are paragraphs 100 to 152 in the trial judgment. So if you see what I mean, that kind of shortcut, because I wouldn't usually start with the trial judgment, a long judgment, when perhaps 90% of it is not contentious. So I'd find out from the clerk, that's the best way to start to get the facts, and a good appreciation of the facts. So that's, I think, their main role is to help with the preparation and digest all that material. They also help in various ways afterwards. I'd always have a debriefing with the clerk, and I'd always have a long memo that I dictate to myself with all the thoughts on this case right after the hearing, because you've got to move on to another case. And they would help. I'd tell them, okay, well, I'm not going to be writing on this. I'm not likely to be. We don't know right after the hearing. But we'll have to watch out for this aspect, that aspect. And we're concerned. We have to be concerned about this aspect of the matter, what consequences it would have, and so on and so forth. And they would help me in doing that. And then I would ask for their comment memo when a judgment is in circulation. Often I'd want to do some more research. It came part of the hearing that things were done differently in various jurisdictions, and I want to look further into that. So they help with post-hearing research. They would help in analyzing the whatever judgment is going to come out. If I myself am writing, they may assist me in that way. Some cases I've asked clerks, why don't you try to come out with a first, une première ébauche, a first draft. I usually found that more difficult than not, though, because I found sometimes I'd have the work and it's like I'm struggling with what's on the screen. I found it's a lot better, and I could get better assistance if I go through. I have to be inside the judgment when I'm writing. And I could get assistance at times if I'm writing through and I get to a point where then I ask the clerk, put some flesh on this. I want to describe what the Court of Appeal said on this and move on. So whichever way can work. Some clerks, and some are more able to do that than others. Generally, I have found that it's, even though some clerks are very good writers, let's face it, well, I've been writing judgments for 23 years now, and I find it very, very, very difficult. So to expect a clerk who's usually just out of law school, it's a very difficult task. So I have found that's not where you can be helped the most. And the clerk would know, I'm writing on such and such right now, so you can expect some calls. And I'd be writing and say, oh, what exactly did that case say? Did we ever use that phrase? You have to watch every language, every item. So I'd phone my clerk and say, could you check the Supreme Court decisions? Have we ever used the words clear and substantial, or, is this new? So a lot of assistance in that way, so I don't have to stop my writing and go look at all those decisions. And then the editing and everything. So clerks are very valuable. We divide the cases, so not the 3 clerks aren't working on each file, but a case where we've sat 9, you'll have 9 clerks from different cabinets all working on one case. And that's very helpful as well, because they're all bright people. We tend to get the brightest and the best. It becomes like a mini think tank up there, because those 9 will discuss the issues and try to sort out what's the best answer, and they can help us that way and think through a problem. We each have discussions with our clerks about what is confidential, and I tell my clerks, like, our exchanges, are confidential. Use your common sense, but whatever musings I have with them and trying to find out how would that work or whatever, of course they can share that with other clerks. They can share the thought, the thinking. They don't have to add, well, Justice Charron thinks that. So Charron says this or that. Let's keep that to ourselves. But it's not. It's a collaborative atmosphere. It truly is. It's not. Oh my, somebody's going to rob my idea. Of course not. We're all struggling to try to find the best idea.